Coming up for 6:45. Hello again, and thanks for staying with us. So the legal battle between President Cyril Ramaphosa and his predecessor, Jacob Zuma, will finally be heard in the Johannesburg High Court today. The tussle between these men stems from the summons which Zuma served on Ramaphosa last month. In the documents, he accuses the president of being an accessory after the fact in crimes allegedly committed by Advocate Billy Downer and journalist Karyn Maughan. Zuma accuses the pair of leaking confidential medical records, but the president says the summons is defective and of no merit. Let's make sense of all of this for you now. Bring in Accountability Now's director, Advocate Paul Hoffman, live to us via our video link this morning. And Advocate Hoffman, always great to have you on the program. Thanks so much indeed for making time to speak to us. So, vexatious, frivolous, a personal vendetta to settle scores. These are just some of the adjectives that have been used to describe Zuma's attempts in this process. How do you see it?
Well, I think what is really happening is that Zuma is just trying to buy himself some more time by tying up as many people in as many different ways as possible with sideshows that prevent the commencement of the criminal trial, which has been coming his way since about 2005, when Shabir Shaik was convicted for corrupting President Zuma in their financial advisor-client relationship going back to a previous century. So the trial judge in the corruption matter that Zuma is facing at the moment has already said that Billy Downer has done nothing wrong. It's a little bit difficult to understand why the President Zuma has sought to prosecute Billy Downer and Karyn Maughan, who is the journalist that he is alleged to have illegally leaked information to. But it is certainly a huge stretch to suggest that the head of the national executive is an accessory to that crime, when our Constitution has a separation of powers principle which does not allow the executive to interfere in the work of the National Prosecuting Authority.
Yeah.
So if anybody is an accessory, it would not be the president, because he is the head of the national executive. So really there is no merit in the case at all. I have no doubt that the courts will give Mr. Zuma and his legal team short shrift, but that will not dissuade him from appealing and appealing again, and then asking for rescission after the last appeal has been refused. That is the way that Mr. Zuma has managed to keep from starting the criminal trial, and this is just another stratagem in order to stop the start of his criminal trial. So let's be frank about it. The courts need to case manage this particular matter with great attention to detail and with the minimum of delay, because otherwise it is just going to keep the can being kicked down the road in the prosecution, which has been pending for such a long time.
Yeah. I want to hold on to that reflection and pair it with this quote from Ramaphosa's replying affidavit. He says, "The purpose of the prosecution is not genuinely to obtain a criminal conviction in respect of a criminal offense, is to harass the applicant for political ends." So if we're to believe that there's some kind of ultimate strategy taking place here, and that this is in fact connected to politics in one way or the other, how then does the judiciary prevent itself from being marred in all of that, or being drawn into it, especially because in some ways some people can see where it's going?
Yes, I think that it is true that the timing of this prosecution, because remember, they didn't ask, when they asked for their certificate of noli prosequi, President Ramaphosa was not involved in the, directly anyway, in the dispute. They were after Mr. Downer and then after journalist Karyn Maughan, but they weren't after President Zuma. But they are seeking, in this particular stratagem, to abuse the ANC's step-aside rule. Remember this latest move, joining the president as an accessory after the fact, issuing summons against him as an accessory after the fact in the criminal prosecution against Downer and Maughan, happened on the eve of the elective conference of the ANC.
That's right.
That is what the president is alluding to in the quote that you've just read to me. What was going on there was an attempt to persuade the delegates that the step-aside rule should be invoked because there is a pending prosecution, even though it is a private prosecution, against President Zuma, and in that way disqualify him from standing for the office of president of the ANC. Well, that stratagem did not work. The ANC allowed President Zuma to be a candidate in the election held last month, and we all know that he won that rather more convincingly than he won back in 2017. So, yes, there is a political dimension to it, but I think that the courts are quite careful to deal with the legal aspects of the case, and that if it is an abusive process, then it is an abuse of legal process.
Right.
The fact that it has been done for a political motive is really not front and center in the judge's deliberations in the matter.
Yeah. Speaking about how careful the courts are, we've also learned that it's going to be heard by a full bench in the High Court sitting in Johannesburg as opposed to just one judge. Initially, the Jacob Zuma Foundation appeared to be kicking up a fuss about it, but yesterday, Mzwanele Manyi, who was speaking to us on Newzroom Afrika, appeared to be a bit more measured about how they're actually seeing that particular development. Typically, in what instance or in which instance would a matter move from being heard by just one presiding officer to being heard, in this case, by three judges?
It happens in matters of importance, and it happens in matters where it is very clear that whoever loses is going to appeal. So rather appeal the decision of two or three judges than the decision of one judge, and cut out one stage of the appeals process. If you imagine an ordinary application heard before one judge proceeding on appeal, it is possible to go to the full bench, and then from the full bench of the High Court to the Supreme Court of Appeal, and then from the Supreme Court of Appeal to the Constitutional Court, if it's in the interest of justice, in the opinion of that court, to entertain the matter. So you see that there are several steps of appeal. By having three judges right from the get-go, what you do is you take out at least one stage of the appeals process, and that is an indication that the court sees this as a matter of sufficient moment to justify tying up three judges for the day in order to reduce the number of appeals that may eventuate.
Yeah, in some instances, it's been called one of the biggest court cases, perhaps, at least in politics, for 2023 so far. Advocate Paul Hoffman, always great getting your insights. Thanks for helping us connect the dots. Advocate Hoffman is the director with Accountability Now. Thanks very much indeed. All right.